There we go. Okay. Good afternoon, everyone. Having a little technical difficulties this afternoon. I've never tried a scheduled Facebook Live event before, so I hope I figured it out and it's doing it the right way. But I wanted to make sure I was going live from the event I created for this, so anybody who is following it would get the right notifications and everything. And I've been struggling to figure out how to do that. So sorry about that. Hopefully I'm doing it right and you all are getting the notifications that you wanted, so you can join us for this time here. Basically what I wanted to do is give you all basically an overview, an update, clarification, if you will, on the Supreme Court happenings. So most, if not all of you, probably know that the hearing that was held last week on Wednesday, September 9th, is that was a hearing from the Midwest Institute of Health case for 3 doctors' offices and 1 patient that sued the governor, the attorney general, and the director of the Department of Health and Human Services of Michigan. And they are, I'm doing a live. Yep, I'm doing a Facebook Live. Do you need me for something? Oh, just the list? Awesome. Thank you very much. Have a wonderful weekend. So we so that's the case where they sued in federal court, and the judge in federal court said that if there is a way that they can solve the case based on state court issues alone, or state law or state constitution issues alone, then why bother deciding it on the federal constitution or, federal statutes? They could just pin the whole case essentially on the state court issues. So because these specific things had never been decided in the Michigan Supreme Court, they did what's called certified questions. So there were 2 questions that were certified to the Michigan Supreme Court, asking them to hear, to decide or clarify these particular issues. The first question, oh, that's not in this thing. You need to get your schoolwork done now. Multitasking, it's a fun thing. So the 2 questions were, is the governor's executive orders after April 30th, do they violate the state law on point? There's the EPGA and the EMA, the 1945 and 1976 law. The second question was, do either the EMA from 1976 or the 1945 EPGA, do either one of those violate the separation of powers clause or non-delegation doctrine or non-delegation clause of our Constitution? And so the answer to both of those is yes, it's illegal, and yes, those statutes are unconstitutional anyway. So we had briefs submitted, I want to say throughout July and August, and then the hearing, of course, was held last Wednesday. And that's the one that started at, we logged on at like 9 a.m. And the court officially accepted us into the Zoom meeting at about 9:30. And then we had they had some technical difficulties getting the public feed connected. And so that was maybe, I don't know, 10 minutes or so, 10, 15 minutes after the scheduled time for 9:30 that we were actually able to start then because of that public feed not quite starting on time. Anyway, that went for, I want to say 1:15 or 1:30 was when we were finally done. I think I spoke around 10:15, and of course there were other attorneys. The legislature's attorney went after I did. I was the second. The first attorney was the plaintiff's attorney representing those doctor's offices and the patient. Then I spoke, then the legislature's attorney, then the I believe it was the attorney for the governor, and then the attorney representing the AG's office, and then the attorney representing the House Democratic Caucus. So, Emma, you gotta stop. You're distracting me. Thank you. She's rearranging all her papers right now. So the whole thing ended up being quite, several hours, and a lot of discussions were had. There were some key points that I had made that, I had made that as of last Wednesday, we were already at 183 days of being in a state of emergency, continued and discontinued and restarted and continued and stopped and restarted states of emergency from our governor's declarations. So now we're at 192 days. No, that's not right. Yeah, 192 days. So that's more than 6 months. And I pointed out to the court that it was already extended yet again with Executive Order 2020-177, which pointed out there were at least 177 executive orders, which by my last count as of yesterday or the day before was actually up to 181. 181 executive orders from our governor during 2020 alone. She was executive order happy in 2019, and we had states of emergency. In fact, our entire state was shut down with the, oh my gosh, what did they call that? Oh, anyway, the polar vortex. So our state was shut down because of that. If I recall correctly, it was for a whole week that we were shut down. So at any rate, even with all the different things that happened in 2019, our governor issued 19 total executive orders in 2019. That's it. In fact, between 1993 and 2019, governors in the state of Michigan issued a total of 605 executive orders. Total. That's it. 605 from 1993 all the way through 2019, which would be 26 years. So 26 years divided by 605 on average. I'm not good at that math to do that in my head. Yeah, an average of 23 executive orders. Now, keep in mind, those are not emergency orders. In fact, from 1993 all the way through 2019, there were only 25 emergency powers orders in the state of Michigan. From 1993 through 2019. So that's less than one per year. 26 years, and there are only 25 of them. That's less than one per year. And those include the ones from Governor Whitmer's first year in office. Additionally, of those 25 executive orders, which came from a variety of governors, including Governor Whitmer herself, every single one of those executive orders hinged upon the 1976 statute as its source of power. None of them used the 1945 statute as its source of power. In fact, only one of them, and none of them that were written by the governor, Governor Whitmer, that is, only one of them in all those years, I believe it was Executive Order 2010-7. That one referenced the EPGA once in the history kind of context part, but not in the part where it talks about the authority for that particular executive order, because it's not designed to do that. So it goes in conjunction with the more specific, more recent 1976 statute. So those are the issues that mostly were debated or articulated in one way or the other last Wednesday. But by the end of the day, I think it was 4:51 to be exact, we got an email from the Supreme Court that indicated there are two additional questions that they wanted briefed by Wednesday of this week, which was September 16th. So was there a Supreme Court hearing on Wednesday, September 16th? No. Did anybody on this case or the legislature's case address the Michigan Supreme Court on that date? No. The only thing that happened is that there were 6 briefs filed in the Michigan Supreme Court on that case on Wednesday the 16th. There was 1 filed by an amicus party on Tuesday the 15th. So 7 total briefs were filed. So the 2 questions that the Supreme Court wanted answered were, and I guess I can't tell the way that this is set up, if you guys can see the original post I made that talked about this video is going to be happening at 2. The original post has the link both for the court order that came out on Wednesday, September 9th, as well as my brief that I filed with the Michigan Supreme Court this Wednesday, September 16th. So both of those are available on our website, restorefreedomkh.com, but the direct link to those is available through the original post I made. And so I don't know if you can see that through this particular Facebook Live right now or not, but if you can't, if you go to our website, restorefreedomkh.com, and you click on the resources tab, then you'll see documents as one of the very first options. You click on that. The very first option for documents drafted by Catherine is the brief that I filed in the Michigan Supreme Court on Wednesday, and it has the date right in the name of the document. And then if you go to, I want to say it's government documents, which is like the next heading over or down, depending if you're on your phone or a computer. The very first one of those, the wording of that order is exactly how it was saved and sent to us from the court. So it's a bunch of numbers, basically, I think it is what it is. I think it's the court file number and the date, and then it says OR for order, I believe. So the 2 questions that were addressed that particular order was asking for are, number 1, whether the Emergency Powers of Governor Act, the EPGA of 1945, which is basically MCL 10.31 through 10.33, whether that applies in the context of public health generally or to an epidemic such as COVID-19 in particular, and whether, the second question is whether public safety, as that term is used in the EPGA, the 1945 Act, whether public safety, as used in the EPGA, is a term of ordinary meaning, like you and I would know that to be in the case of conversating about it, or whether that term, public safety, in the EPGA has developed a specialized legal meaning as an object of the state's police power, and whether public safety encompasses public health events such as epidemics. So some people have thought about this very simplistically, just like, oh, so the court's asking you to define public safety and public health. Kind of. And if you think about all the wording there, that sounds very complicated and kind of convoluted, the way that the questions are worded. And to a certain degree, I would agree that that's the case. Basically the best way, the parts of a Supreme Court brief, which for the most part is the same with a Michigan Court of Appeals brief, just to kind of walk you through it. Hopefully you guys will be able to see this. So this is basically the caption. This is who the parties are. Et al. Means there's additional people listed in the actual court file that are not completely listed here. So this is the Midwest Institute of Health, PLLC, doing business as Grant Health Partners, et al. So there are 3 other named parties that are plaintiffs. Governor Whitmer et al. Means there are additional parties named as defendants with her because it's Governor Whitmer, the Michigan Attorney General, and the Director of the Michigan Department of Health and Human Services. This is the Michigan Supreme Court number, but this number is showing that there's actually a companion number with the U.S. District Court, Western District, and that's the court file number for that. And then this right here is indicating that this is in Ray, the certified questions from the U.S. District Court, Western District of Michigan, Southern Division. So down here, my initial brief was brief amicus curiae in defense of the U.S. Constitution, the Michigan Constitution, and the rights of all citizens. So this is essentially what they're asking for was supplemental briefing. So I kept the title in that sense the same, but then indicated that this is a supplemental brief filed pursuant to the September 9th, 2020 order of this court. And I don't think that there's going to be additional oral argument on these particular points. I really don't. But what I asked for was that oral argument is requested if being held, and that would be contingent, of course, my being allowed to participate would be contingent upon the court's permission under Michigan Court Rule 7.312H5. So that's the court rule under which I was allowed to participate the first time. And there's no guarantee that I would be allowed to participate in the future if there was additional oral argument to be heard on this case, because I'm not an official party to the case. But I am requesting it if they do oral argument on it. So, and then this, in case you're wondering, the Supreme Court and Court of Appeals stamp on the side when the briefs are received. So the very next thing, now this is a supplemental brief, so I didn't put some things that you would put in a normal beginning brief. So for example, the brief that I will file in the legislature's lawsuit against the governor, now that the legislature has appealed the Court of Appeals decision, the brief that I'll file in that case is going to have more stuff in there than what this brief has. But in addition to that, my amicus brief won't have as many sections as the brief of the parties. So the doctors and the governor, the attorney general, they're parties to the case. And so they're going through their initial brief is going to have more detail because they're going to have sections like a statement of facts and basically the procedural history, those kinds of things. That's not exactly relevant to what I'm talking about. My sole purpose is to help the court, given whatever the facts are by the parties, let's figure this out on the basis of law and on the Constitution. So just to kind of help you guys understand that part. Okay, want to make sure I don't have any questions so far because I don't want to lose you guys. I don't sound hopeful. Darla, if you were talking to me, I'm not sure what I don't sound hopeful about. I'm just, to be honest, I was struggling because I had a friend here talking about my siding, that my house is kind of in bad shape on the outside just a little bit ago. And then as soon as he left, I hopped on here trying to figuring out the technology, which I struggled with. And then I had a volunteer that needed to leave in the middle of me beginning this. And then I have my 6-year-old who's trying to do homeschooling and was tapping her pen repeatedly on my desk and shuffling her papers while I was trying to concentrate. So that's kind of where I'm at with things. So, so far I haven't tried to give you any kind of inflection in my tone about whether I'm hopeful for this case or not. I'll get there, but I hope you didn't take any of those frustrations about how my day is going in general on whether this case is going well. Giuseppe, she has actually been a wanted lawbreaker since at least, what would it be, March 10th in my book. But, okay. Yeah, see, we didn't even remember about the polar vortex because all this craziness happened. Didn't know that happened in 20. Nothing, Adam, you're pointing out about the federal court judge in the Pennsylvania case. That, I have one of them printed here. There was a case that happened in the Wisconsin State Supreme Court, but that was just a preliminary injunction. And then there is I do have the Pennsylvania case right here. I did not have a chance to read the whole thing, but this is, just to be clear, this was something that was filed 4 days ago on the 14th, and it is a 66-page document, so I have not had a chance to read this. But essentially even though my very brief read through of this so far is that this order is a good thing, it's a trial court order. So that means there's no precedence here. This is not something that is binding on any other court, on any other case, because it's a trial court. It'd be like if the judge in a divorce case in your county decided something, that judgment cannot be used against somebody else getting divorced in the next county over. They're both trial courts. So they would look to the Court of Appeals or the Michigan Supreme Court for whether something was a particular point of law. So basically, though, this Pennsylvania order, they're starting to move. So there's some interesting things in here, of course. But one thing he points out in here is that the gathering limits, so the limits where you can only have so many people gathered for any particular purpose, those gathering limits imposed by the defendant's orders in the Pennsylvania case violate the First Amendment. So that is one of the things that he said in here. They talk about some level of scrutiny and all that. Quite honestly, I think all that's garbage. Whether you have intermediate scrutiny or strict scrutiny or one of the lower levels of scrutiny by a court looking at an action of government, all of that is a bunch of hogwash, because the Constitution is the Constitution is the Constitution, and it should all be strict scrutiny if the government is stepping outside of the bounds of what they are permitted to do in the Constitution, or if the government is trampling on any of our rights that are provided for, that are, protected within the Constitution, or even those that are in the 9th Amendment, the unenumerated ones. It should be strict scrutiny. Our government should have no wiggle room whatsoever, not one little scintilla of wiggle room, because the Constitution is the Constitution and the government can't change it. The people can change it, but courts cannot just take an eraser and their ink pen and start all over again to a certain section. No, that's not how it works. So at any rate, so the congregate gathering restrictions fail this intermediate scrutiny test. That's what this court said. And the defendant's orders violated plaintiffs' rights to substantive due process under the 14th Amendment. So far this trial court said that the orders precluding people from gathering as they want violates the U.S. Constitution's First Amendment and 14th Amendment. And it's kind of a long order. And it goes into a bunch of different things. The stay-at-home provisions of the defendant's orders are unconstitutional. Good, because they are. The business shutdown components of the defendant's orders violate the due process clause of the 14th Amendment and a bunch of other things. How about the 9th Amendment? How about the issues with the Commerce Clause and takings And I mean, anyway, we won't even get going there. So, this court also said that the 14th Amendment guarantees a citizen's right to support himself by pursuing a chosen occupation. And there are quite a few other points that are made here. The business closure provisions of the defendant's orders violated the Equal Protection Clause of the 14th Amendment, which I would absolutely agree, that's especially happening here in our state, because you could always get an abortion, but you couldn't get a hip replacement. That's something. You could always get a bottle of booze, but you couldn't get some paint for your house. Interesting. So these, anyway, that is the, regarding Governor Tim Wolf, and that is in the Pennsylvania Federal District Court. So that's a trial court. It just doesn't have the weight that a lot of people are hoping that it does. So just wanted to explain to you some of the things. Oh, shoot. This does not allow me to go back any farther. Okay, so sorry, I missed a bunch of questions. I took too long, I guess, answering that one. So the top one that I can see, or the most farthest back, oh, okay, I can't see that one anymore. Can you read all of the briefs? I believe if you go to the front page of the Michigan Supreme Court's website, they do have all of the briefs on there. I have not checked this go round to see if all of these particular briefs for this supplemental briefing stage are put on there, but I would guess they are. When do I expect a decision? Yes, we'll get to that. Mandates that align with the, Well, Darcy is asking about what happens to the MDHHS mandates that align with the executive orders with a positive ruling. So that's what I've been trying to tell a lot of people all along, is that let's say, for example, we get rid of the 1945 law. My understanding is Stand Up Michigan has turned in, or is about to turn in on Tuesday, when session is back in session. Legislature is back in session. They're going to turn in all their petition signatures. So let's say that the Secretary of State goes through and determines that they do in fact have enough good, valid signatures turned in. And it goes to the legislature for the legislature's 40 days to begin to determine if they're going to go ahead and make a vote on it, whether they're going to repeal the 1945 Act. The issue that we're seeing is that we have the governor having the local health departments doing her bidding for her, if you will, by utilizing elements of the public health code and some other related provisions where they are writing emergency orders pursuant to other state laws that have absolutely nothing to do with the state of emergency. Nothing. So we can get rid of the 1945 law. Shoot, we could even get rid of the 1976 law, and we're still going to see the local health departments causing problems with these emergency orders unless we do something about the public health code. So let's see. I have not heard about a 2-month-old dying of COVID. I don't believe anything that's in the news. I don't believe anything that comes from our government at this point. Okay, so I guess let's do this. Give me a few minutes, because once your questions go to a certain point, I can't scroll up and see them anymore. So I have the question of when do I expect a decision? And I have the question of, if this is found to all be unconstitutional, what happens next? So I have those that I could see that a few people have asked those two questions. So let's try to keep, yeah, some of the same. Sorry, I'm going to see it. There's still more in here. I sure hope that that Stand Up or any other group is going to make copies of the petitions before they turn them in. I will definitely have multiple copies of the petitions for the Restore Freedom Initiative petitions before I turn mine in. But I honestly don't know what they're going to do either way. Oh, awesome! You just got your Restore Freedom jacket that you'll be wearing when you go to vote in person. I love it. Yep, you could buy a lot of lottery tickets, but you couldn't buy garden seeds. You like I said, we could have the liquor stores open, but you couldn't have a comic book store open because the liquor store might sell a protein bar, maybe, but the comic book stores that actually had a regular stock and sales history of all kinds of food items didn't qualify. Interesting. Yeah, you're right, Maya. We definitely need to do something about the public health code. Just for any of you who haven't, some of you who watch my videos or listen to what I talk about in terms of like the constitutional aspects of things or the court aspects of things, but you haven't really checked into what the Restore Freedom Initiative is all about. That's the constitutional amendment that I wrote to change all of this once and for all, that this is not going to ever happen again, because it's not going to matter what law they're trying to rely on. Every single one of those unconstitutional laws is going to be stricken right away. They will not be able to deny us of our life, liberty, or property unless they first prove that it's necessary to do so because we are imminently threatening to or are currently depriving somebody else of their life, liberty, or property. So, for example, if you commit murder, you've robbed somebody else of their life. If you are stealing your neighbor's car, you are robbing them of their life, liberty, or property. So there could be consequences for that. Absolutely. That's part of living in a society. But if you are not harming somebody else's rights to their life, liberty, or property, the government has no right to take away your life, liberty, or property, not just without due process. They don't have a right to do it at all. So there would be a high burden of proof, a proof beyond a reasonable doubt standard that that the government would have to show proof beyond a reasonable doubt that it's necessary to do so because you're harming somebody else in those ways. So that's one of the very first things in there. Let's see. Anyway, there's a lot. Basically, my point is the Restore Freedom Initiative, it gets rid of the 1945 law. It gets rid of the 1976 law. It gets rid of the public health code provisions that violate our Constitution. It gets rid of every single one of those things that violates our Constitution. In fact, if we're going to be regulated as a people at all, the government can regulate itself all it wants. Absolutely. Regulate yourself. Go ahead. Go for it. Government's so big, you might as well start regulating itself. If the government's going to regulate us, the people, then they have to do so by a 2/3 vote. Either a 2/3 vote in the done on the ballot, or a 2/3 vote in terms of what the legislature votes for us. Any law that has not passed by a 2/3 vote and it's serving to regulate the people now, will not be kept on the books. It will not be enforceable any longer. So bye-bye unconstitutional provisions of the Public Health Code. That's why I need your help getting signatures. That's why we need to get 425,059 signatures. And we need your help getting them now. Stand Up Michigan is done with theirs. The recall group, as far as my understanding, isn't starting until October 10th or something like that. We're going. We're going strong, but we need your help. We need every possible signature we can get, and we need them now. We don't need them in a week from now or a month from now. If you like your freedom, fight for it now. Get the signature of every single possible person that you can now. Make sure they're a registered voter. Make sure they're filling it out right. But we need their signature now because we need this constitutional amendment to show everyone no more. This is our freedom. It's our state, and we're going to take it back. And once we do that for our state, you don't think the whole rest of the country is watching? You don't think this is going to have a ripple effect all across the United States where people are going to see what it's like when the people stand together and fight for freedom and they take back their government and they take back their lives? It's going to have a profound impact on the entire country when people see how we can work together like this. Absolutely. Could the same problem happen with the 1976 law if the Democrats rule the legislature? I'm not sure exactly what that question was, but other than that, other than to tell you, that's exactly why we need the constitutional amendment that I wrote. The Restore Freedom Initiative gets rid of it. It gets rid of all those unconstitutional provisions. And quite frankly, the 1976 law is far worse for us than the 1945 law, by far. If you've missed any of those videos where I've gone through and I've identified the different provisions where they could take away your stuff, they could force you to perform labor and different tasks because it's going to help the emergency. They can take your home or your business or your other property and utilize it for training of a disaster or an emergency, any of those things. It's awful. And that's under the 1976 law. Okay, so it's just... Eek! The questions are coming in really fast, at least from what I can see here. So... Oh my gosh, guys. Okay, slow down the questions so I can address what was already asked, and then I'll go through what's there because I'm about... yeah, you're right, Maya. You could buy booze but not attend an AA meeting. That is darn straight. You couldn't go to counseling. You couldn't go to marriage counseling. You couldn't go to group therapy. You couldn't go to anger management. You couldn't go to any of those things. But you could buy your alcohol and you could have an abortion. All things that are quite helpful for us as a society. Trying to keep our churches shut down and afraid to open. Okay, so there were questions and now I can't remember. So fast through here. So the 1945 repeal, it's not that it doesn't do anything. It's a step, right? We need the 1945 law gone. We need the 1976 law gone. We need the public health code provisions that violate our constitutional rights. Those need to go as well. So that's why I was really hoping that Stand Up Michigan was going to keep going. Get the 1976 law out of there. Get these bad parts of the 1945, or excuse me, the public health code out of there. They could do that. That group gets thousands, hundreds of thousands, almost probably over $1 million of donations so far at this point. They can do it. They have the funding. They have the resources. They're paying for out-of-state circulators to come and help. So all of this is something that they could do. So try to talk to them. Talk to Garrett, talk to Ron, talk to whoever else is in charge of that. Try to talk them into doing another repeal. Absolutely. Because the constitutional amendment can only be done by a vote of the people in the 2022 election. And if the repeal, if the 1945 repeal doesn't get voted on by the legislature or they vote no, then theirs will also go in the same November 2022 election. But in the meantime, they could still try to talk the legislators into doing the right thing and start repealing them. Oh my gosh, you guys are blowing it up again. Okay, so as to when, I'll answer that very quickly. I don't have an answer for you. What I can tell you is that based on the fact that the Supreme Court had all of this done in a fairly expedited manner, so they gave all the parties and amicus parties the time to write their briefs, then they had oral argument time, then they only gave sorry, there's a lot of comments and questions, so I'm hoping I'm not missing a ton because you guys are going to town. So anyway, yes, businesses receiving fines. I'll try to remember to address that too. So shoot, where was I just going with this? Anyway, the briefing schedule. So then they gave only 1 week, literally with the order issued at 4:51 on Wednesday to then a 5 p.m. deadline of the very next Wednesday. It's a very tight briefing schedule. You might think, oh, a whole nother week, it's stretching it out. I'll tell you what, do you know how long it took me to write this brief? Just answering those few little questions, which I didn't even get to talk to you about yet, 41 minutes into this. I haven't even told you what my answers were. It might seem like they were this is how my argument was broken down. It might seem like it's not that much, right? I didn't even take up, as you can see, whoops, I'm going the wrong direction. There's not a lot because we have all this open space on this piece of paper. I'm actually, well, I'd like to think that I'm very fast at writing briefs. Maybe not. Maybe I'm terrible at writing briefs. I guess we'll find out at some point. But I am a perfectionist, and I didn't even have time to give it the perfectionist, 12 times around thing. I got to read this whole thing. I sat down and I started typing, and I just started typing, and I kept typing, and I just kept typing and typing and typing. And I didn't go back and add and move things around. Nope, I just went all the way through and was typing. And then luckily I had just enough time to go back and read the whole thing once through. And then I was able to make a few changes. Just doing it that way alone, I can't even tell you. I could tell you for 2 days straight, that's all that I did. I mean, I shut out my team. I didn't hardly answer text messages or phone calls. I didn't even join our daily Zoom meeting that we have. The Restore Freedom Initiative core team members meet every day, 7:45 a.m. I did not join 2 days of that because I was solely focused on this. And it's a lot. So even for somebody who doesn't take a single day off and still hasn't since this all began, for anybody who thinks that the court allowing a week to have these briefs submitted, I'm telling you, that's a very expedited schedule. Absolutely. I mean, look at the fact that 6 of the 7 briefs that were submitted under this order, 6 of them all came in the afternoon on Wednesday. The afternoon on Wednesday. None of them were submitted later in the evening, the last Wednesday, first Wednesday the order came out. Nobody submitted their briefs the next day, Thursday, or Friday, or Saturday, or Sunday, or Monday, or 1 on Tuesday, none on Tuesday morning, and 6 on Wednesday afternoon. It's because it's a lot of work. It's a lot of work to do that. And so I want you guys, so why am I telling you about that? So you guys have hope that you might think in the context of something that a whole week to work on something is just a huge, long period of time. But in the legal world of doing all that work and all that briefing, I mean, I thought I had a lot of stuff printed on this subject. I mean, I have oodles of statutes. I have hundreds of cases, state and federal. I'll show you guys just an example. To go get them all. Okay, these are just on one of 2 cases. Either everything in here is a brief that's written on the legislature's lawsuit against the governor, or the federal case that has the 2 certified questions that we're talking about right now. It's one of 2 cases. I don't have every single brief printed. Well, I certainly don't even have the new ones printed, except for mine. And I don't have any of the appendices printed. There are thousands of pages of appendices that I've looked at, but I haven't printed. even considering all that I haven't printed. Let's see, this right here is the initial binder from the legislature's lawsuit against the governor, from the very first pleading that they filed. This is double-sided, okay? Then they filed a bunch more stuff, and this is starting in the Court of Appeals and Supreme Court. Again, double-sided. This is on the federal court question, okay? So this is only one level of court, and it's all this, double-sided. And then I started another binder. So all of this tells you that, just think of how many hours. Now, keep in mind, I don't have a paralegal. I don't have a legal secretary. I don't have any of that. My husband helps me print stuff, but my husband's a machinist. He's not an attorney. So he does his best to help me, but he's a machinist, not an attorney. And it takes sometimes a whole day or two nonstop, working 18 hours a day, just printing all this stuff. These aren't the statutes. These are just the pleadings. These are just the briefs and the motions filed by the attorneys in these two cases. This isn't all the other cases. This isn't Carl Mankey's case. This isn't, the Wisconsin case. This isn't the cases with all the hairstylists that had Operation Haircut and they were receiving tickets and all that. This isn't any of those. This is simply the two cases that we're talking about. And it's just the briefs and the court orders. So when I had to print all the statutes that are involved regarding defining the public health code and, public health and public safety, that took an insane amount of time just to print all the relevant statutes, let alone to read them and write them. So the reason why I'm telling you, spending all that time to tell you, is I wanted to give you, sometimes people are visual. That's a crap ton of paper, right? I had just as much paper to print in the last few days to print all these statutes and cases and read them and blend them all together into a brief. So it's a very expedited thing. So I believe strongly that we're going to have a decision from this court within, what is today? Today's the 18th. I'm going to go on a limb to say that we will have a decision by the Supreme Court by the end of this month or beginning of October. I truly believe that we could have a decision by September 30th from the Supreme Court on this. Am I going to guarantee you that? No. No, I'm not. But I truly believe that given the expedited briefing schedule, given the fact that we were given 7 days as attorneys to do all that, there's a good chance we're going to have that decision. The fact that they also know how important this is in terms of rushing up the timing of things does give me hope for the overall outcome. If they didn't think it was that important, if they thought it was ordinary run-of-the-mill stuff for the government to be making decisions on how many people we could hang out with, on whether we were able to hug people, or whether we had to wear masks at church services or funeral services or our weddings, whether we could buy certain items at stores, or whether businesses, private businesses like movie theaters couldn't be open, but whatever, a store like Meijer could be, or what, like COVID's going to know the difference between the groceries and sitting in your own spacious, like 6 foot, whatever. I can't even think of spatial concept names today, but a lot of movie theaters have those recliner chairs, right? So the one that I like to go to in Holland, they have the recliner chairs, and I am nowhere near anybody else because there's at least 6 feet in between me and the person in front of me and the person behind me, and there's quite a bit of distance between me and the person next to me. I mean, you can't hardly even hold the hand of your spouse if they're sitting in the chair next to you at that movie theater. So, I can comfortably, very comfortably sit my 6-year-old next to me in the seat at those big movie theaters, but they can't be open. So at any rate, the point being, if the court thought that all of those restrictions were par for the course, why would they hurry up this briefing schedule? Why would they say, oh, we need to have these answers right away? I'm not convinced that they would. So I am very hopeful that they're going to wake up and do the right thing. Absolutely. But let's keep the pressure on, right? Of course, the legislature can repeal the 1976 law without petitions, but the governor would be vetoing it. And so it would go back to the legislature and they would have to then approve it by a 2/3 vote. Remember, every single one of those legislators took an oath of office, which is required under Article 6 of our United States Constitution and Article 11, Section 1 of our state constitution to support the U.S. and Michigan constitutions, period. Not to make sure that they, maintain political backing, not to make sure that they get reelected, not to make sure that they don't tick off their donors or, the political elite because they don't want to get kicked off of their committees. Their committee assignments are, super important, but, is it really worth the risk of violating your oath of office just to keep your committee assignments? And if you're sitting on your laurels while the rest of us are fighting for our liberties, you're violating your oath of office, period. There's no two ways to look at that. I don't care who you are. I don't care how hard you fought for freedom so far. I don't care how many other bills that you have, been the one person to vote no on or yes on, depending on whatever the situation might be, or, in any other situation where you might have been the best freedom fighter that we know, or maybe you've been a terrible freedom fighter all along. Everyone in between, you have the same oath of office and you have the same job to do, and it does not matter, literally does not matter how much you're going to lose your political backing, your sponsors, how much the GOP or the Democrat Party is going to be mad at you. It doesn't matter if you're at risk for losing your committee assignments. It doesn't matter if the political elite told you that you can't support this or you can't say that or you can't go to Restore Freedom Initiative, freedom festivals. All of those things don't matter. What matters is your oath of office. If you don't think your oath of office supersedes all of those other things, then get out of office. Resign now. Like in the next 5 minutes now. Because if you don't take your oath of office that seriously, you don't deserve to be there, ever. So keep that in mind. The legislature can and should be repealing the 1976 Act. They can and should be repealing those parts of the Public Health Code and the 1945 law without having 340,000 signatures turned in for those things. But they're not. They can't even stand on the steps of the Capitol and tell the public, well, the Constitution does not allow the governor to do what she's doing. So you can go ahead and open your movie theater. You can go ahead and open your gym without mask requirements while you're exercising. You can go ahead and attend a public school without having to be socially distant, without having to miss recess, without being, prohibited from getting the required services for 504 plans and IEPs. You can go ahead and get an actual ABA therapy. You can get your occupational therapy that you need. You can do all these things without having to have masks and be 6 feet away from people, because that's not how humans function, and it's not how God designed us to interact with each other. So yes, our legislature should be doing all that, but we don't trust our legislature. I mean, I don't. Do you? I don't trust them at all. And the thing is, the distrust of our legislature has actually been a pretty historical thing here in Michigan. In fact, I want to say it was in the 2018 Citizens Protecting Michigan Constitution Against the Voters Not Politicians initiative that when they had that lawsuit, the Supreme Court ended up saying that the people retained in our state constitution, we have some strong elements of direct democracy because we have always had a distrust for our legislature. That's why when we created the 1963 version of our state constitution, when we did a general revision back then, we had in there the elements of direct democracy where we could do a repeal, we could do referendum, we can do initiated legislation, we can do constitutional amendments, we can do the recall, if I didn't say that. We can do all those things as a people. We can collect signatures of the people and get stuff submitted onto the ballot for the people to make those decisions because we recognize our legislature has failed us for decades. So if we want to keep relying on the legislature to fix things, then we need to get all of them that are in there out and start all new. I'm not going to hold my breath on having 110 new people get into the state house, or what is it, 38 state senators replaced. We should do that, but I don't know that there's that many good candidates on the ballot because a lot of the same state reps that are currently state reps somehow won their primary elections. I don't know how any of them did, quite frankly, but okay, so in general, I would assume oh gosh, lots. Okay, wow, you guys are going fast here. Okay, and I don't know if there were questions. Let me just go through this, okay? Because I actually didn't get to this. So I'm trying to balance answering questions and being able to talk about, update you guys on what's happening versus what's not actually happening. So my arguments in answering the two seemingly simple questions, there's a lot of context there. So I have a standard of review that I think is important. I'll kind of go through that in a second. And then my first main point is that the government's authority, not just the governors, all the government's authority to act with regard to public health, public safety, and the general welfare of people is actually quite limited by the text of our constitutions. The source of our government's authority to act is something that I talked about then to explain where I was getting that information. And then I talked about the context of public health, public safety, and general welfare in our state and federal constitutions. Then I talked about how the term public safety, as used in the EPGA or 1945 Act, is a term of ordinary meaning and not one that has this specialized legal meaning now. The term public safety does not encompass public health events, and I explained that in detail. And I also explained or answered the question that the EPGA does not apply in the context of public health generally or epidemics such as COVID-19 in particular. So, okay. So I pointed out for the court that as of Wednesday when I wrote this, the state of emergency in Michigan had been going on for 190 days. And that as of that point, there were 181 executive orders. Now keep in mind, and I don't think I spelled this out in here, 11 of those are actually constitutional. Why do I say that? Because 11 of those 181 executive orders were actually executive orders where the governor was simply trying to reorganize a part of the executive branch And she did that in an executive order that she was then presenting to the legislature for them to have 60 days to determine if they wanted to vote to disapprove of that reorganization. So 11 of the executive orders in 2020, 11 out of the 181 are constitutional, as far as I can tell. I mean, I didn't read to see if she did anything else in there, but they're not about COVID. So 11 are okay. That means 94% of these 181 executive orders are on the bat, right off the bat, unconstitutional, period. That's a problem. And then I pointed out to the court, and I said this in my oral argument, that whether it's for 190 days or just 5 minutes, even in times of emergency, our U.S. and our state constitutions do not allow, they don't contain language allowing the trampling of our constitutionally protected liberties or the government to step outside of their given authority. And although that the executive orders were lawful for the first 51 days, they followed state statute for 51 days. Those executive orders were not constitutional from day one, period. And the thing is that I take for granted, but I'll spell out here in case somebody is really truly wondering about this. When you have a law and you have the Constitution and they don't, they're at odds, right? They're butting heads. We have something in the, Article 6, I believe, of Article 6 of our United States Constitution says that any provision of the United States Constitution or any laws made in pursuance of that Constitution, they are the supreme law of the land. And you could have a state constitutional provision, like the Civil Rights Commission in Michigan, the way it's currently designed, or any other part of a state constitution or a state law. And if that is at odds with the U.S. Constitution, it's unconstitutional. It's void on its face. You just throw it out. The Constitution supersedes everything. And that holds true for our state constitution as well. So if we have, let's say, a 1945 Emergency Powers of Governor Act, and that's a statute, it's a law, and then you have the state constitution. If the 1945 Emergency Powers of Governor Act butts up against and is at odds with the state constitution, the 1945 law is unconstitutional on its face, and you have to throw it away. You have to get rid of it. You don't follow it. You can't enforce a law that's unconstitutional, period. I don't care what the circumstance is. It's irrelevant. Quite frankly, all the numbers, the math, the statistics, the diagnoses, what the CDC is saying, what the Michigan Department of Health and Human Services is saying, what Dr. Janae Khaldun is saying is irrelevant when it comes to controlling the people. Totally irrelevant. Why? Because the Constitution does not give exceptions for denying someone's right to go to church or to worship how they deem appropriate to be able to worship God. Our state constitution specifically says God. The U.S. and state constitutions do not allow limits on peaceful gatherings or on petitioning your government for redress of grievances or on, any number of rights that are constitutionally guaranteed to us and given to us by God. It's not the government's job to take away what it didn't give to us in the first place. Government's sole purpose is to protect our rights. Just think about it. We came together as a society, and we want to make sure that in so doing, when we have, 380 million people, I believe, in the United States, no matter what the number is, it doesn't really matter. We have lots of people in the United States, and by coming together, we're forming contracts. We have this way of understanding. We want to make sure that there's a stable way that we can coexist with without trampling each other's rights that are given to us by God. So government's sole purpose is to come together in a way to protect the rights given to us by God. So if the government is in there trampling on those rights, then it's stepping outside of the whole purpose that it exists for in the first place. Anyway, sorry, that's basically the beginning of what I was arguing. So I also pointed out that although these questions, and this is a big thing, although these questions hinge on the definition of public health and public safety, and to an extent it brings in the concept of general welfare because it's oftentimes intermixed with those two definitions, a few key points need to be remembered by all of us, because the legal experts are, quite frankly, losing the forest through the trees. They're focusing on each individual tree, right? The definition of public health, the definition of public safety, the definition of how does public safety encompass public health? Does the 1945 law, cover times of public, a pandemic or epidemic? Let's think about this. The U.S. Constitution says that the Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of the state, of any state, to the contrary, notwithstanding. Judges are bound by this. So I reminded them of that. And any law repugnant to the Constitution is void. And courts, as well as other departments, are bound by the U.S. Constitution. And the laws, the courts of our state are bound by the Constitution of our state. So to the degree that the statutes in question violate any term of the U.S. or Michigan constitutions, the statutes are void, and a full discussion on the terms of public health, public safety, whatever, is no longer relevant. But of course, I answered the questions anyway. So I have I have some case law, right? I've already said I put a lot of case law in my prior briefs. The justices still have access to that. I didn't want to just give them the same briefs over and over again. I assume the other attorneys are not doing that either. So basically, the government's authority to act with regard to public health, public safety, and general welfare is quite limited by the text of our Constitution. So basically, how does this all apply in COVID-19? Well, I go through and I give very specific information on how our own state Supreme Court has described what the purpose of a state constitution is for. The people are the ultimate source of power in all government. And the most basic function of the Constitution is to create a form and structure of government, to define and limit the powers of government, and to provide for the protection and rights of liberty. So to provide for protection of people's rights, but to limit and define the powers of government. And that was said in the Citizens case from 2018, 2 years ago. 6 of the 6 of those justices in that case are still on the court today. We have 7. 1 is no longer on that court. 6 of them are. And so those were the words of the majority back then. So in other words, the government, any branch of the government, can only act in ways specifically authorized by our Constitution. So if there's a state statute that says if the legislature makes a law that allows the governor to do something, but the Constitution doesn't allow it in the first place, that statute is unconstitutional. That's how it works. So you tell me where in the state constitution or the U.S. Constitution the governor has the right to shut down movie theaters, to force individuals to wear masks, to shut down public schools indefinitely. Doesn't exist. So she can't do it. She can't create the authority to do it, and the legislature can't create the authority for her to do that. Because the legislature doesn't have that authority on their own either. They can't just make a law to shut down all the businesses. They can't make a law that requires us to wear masks in public. They don't have that authority. It's not our job to prove that we have a specific right to not have to do that. It's their job to prove that they have the authority to do it to us in the first place. So I go through some other details. So basically, here's a thought, right? So I have grown up thinking that, well, our government says it's there to take care of the public health, public safety, general welfare. In fact, you look at, you do a quick Google search for general welfare or public welfare, and you get the general welfare clause and how, they're supposed to take care of us. And that's in the U.S. Constitution. No, people aren't reading the whole thing. They're taking it out of context. So let's look at that. The U.S. Constitution, the word welfare, not even public welfare or general welfare, welfare at all. That word appears in the Constitution twice. Twice. In the preamble to the Constitution, it reminds us that we established the Constitution and formed our government to, among other things, promote the general welfare. Not regulate it, promote it. So you can make recommendations and promote a certain kind of thing, but you can't regulate something against the people for public welfare, at least not under this part. So that's one of the two times it's mentioned in the Constitution. This is the U.S. Constitution. Then in Article 1, Section 8, we see that Congress has the power, quote, power to lay and collect taxes, duties, imposts, and excises, comma, to pay the debts and provide for the common defense and general welfare of the United States, semicolon. But all the duties, imposts, and excises shall be uniform throughout the United States, period. That whole part is talking about collecting money and paying bills. That's all it's talking about, collecting money and paying bills. So it's finance. Provide for, when they say that the United States Congress has the right to provide for the common defense and the general welfare of the United States, they mean like how a father or mother provides for their children. They work to pay the bills to feed the children. So a husband, and not in a sexist way, but my husband, because I'm doing all this work for free based on donations alone, my husband is providing for me and our kids because my husband is out there earning the money. So now, technically, I'm the one that pays the bills, but that's just the physical side to it. He's earning the money to pay the bills. So if you look at that whole sentence and where there are commas and where there are semicolons and where the period is, which is all important, and I probably didn't put enough emphasis on that. I should have done more emphasis on that point alone. Article 1, Section 8 does not give the government the right to regulate the general welfare of the people, but simply to earn enough money to promote the general welfare, to provide for situations. So, for example, if the government's going to have a way to travel, right, roadways and whatnot, so that people can get access to health care, or if the government's going to account for ways to provide for infrastructure in other ways so that we can have, I lost my train of thought there. Anyway, I was going to give you some examples, but they're gone. So anyway, if you also look at the definition, the British definition of provide for, one of those main definitions is to supply means of support, especially financially. Supporting or providing for financially, again, that doesn't mean they have the right to just regulate us in the general welfare sense. So the term welfare only appears 3 times in our state constitution. That's in Article 4, Section 50, 51, and 52. I'm going to jump and tell you that the cheater part of this, or one of the main points, is that I said Article 4, Section 50, Article 4, Section 51, Article 4, Section 52. That's in the part about the legislature. The governor is not given any powers. The court is not given any powers over welfare. In fact, local governments, which are, gosh, that I believe is done in Article 7 of our state constitution, not given any specific powers for the general welfare of people. Welfare is mentioned 3 times in our constitution, and that's in these 3 specific provisions. Now, does that mean the legislature has the right to just make whatever law they want about welfare of the people? No, we have to look at what those provisions say. So if you look at those, they only provide that our legislature has the authority to, quote, regulate the use of atomic energy and forms of energy developed in the future. That would be Section 50. And, quote, the protection of the air, water, and other natural resources of the state from pollution, impairment, and destruction. That would be done in Section 52. So then that leaves us with one provision, Section 51, which is the one the governor, oddly enough, keeps using like it's one of her weapons against us. Though Article 51 tells us, quote, the public health and general welfare of the people of the state are hereby declared to be matters of primary public concern, the section continues to state that, quote, the legislature shall pass suitable constitutional laws for the protection and promotion of the public health. Let's think about that. So it specifically calls out public health and public welfare, not public safety. Public health, public welfare. These are elements of primary concern in our state. So legislature, we're giving you the right to regulate just one of them, just public health. So we're going to recognize public health and public welfare are super important, but that public health can be regulated in some way, but public welfare, not so much. In fact, not at all. The words that are in the text of the statutes and the Constitution, as is here, are just as important as the words that are not in there. So that's it for public welfare or any kind of general welfare concepts. That's it. Those 2 times in the U.S. Constitution, 3 times in the state constitution, that's it. So you hear anything else to the contrary, you got to ask them, what's the authority for that? Because our U.S. and state constitutions don't give the authority to regulate the general welfare at all. So let's look at the term public safety, right? Because that's of those 3 big pieces, right? Public safety, public health, public welfare, they all kind of, at some degree, they kind of intermingle. They shouldn't, because they're actually all separate. And they are listed in our state statutes. In fact, I'm going to tell you an example of how they are listed. Okay, so for example, in the Public Health Code, MCL 333.111 subdivision 2 talks about the code, the Public Health Code, being liberally construed for the protection of health, safety, and welfare of the people of the state. Well, obviously that's unconstitutional, but my point in quoting that is that they're separate. Health, safety, and welfare are, in fact, deemed as different things. If you look at MCL 10.81, energy emergency means a condition of danger to the health, safety, and welfare to the citizens of this state. MCL 333.201651F. Yes, I read all of these. Hence the reason why I was unavailable to several people who needed my help for several days now. Quote, regarding a patient's health, welfare, or safety. So even at an individual patient level, we can see that it's broken down to health, safety, and welfare. Or MCL 333.20168 subdivision 1 that, quote, affects the health, safety, and welfare of individuals receiving care. I could have gone on and on and on. I honestly just ran out of time to put together the 47,000 things that will prove all of these points. My point here is that health, safety, and welfare are considered the three legs, I guess, of how they decide they get to regulate us in general, right? Anytime there's just general regulation of us. Well, that's why I wanted to break this down, because the questions that came from the court are asking us to think about if the EPGA relates to public health, if it covers times of specifically like a epidemic or COVID-19, if the concept of public safety encompasses public health. All of those things are what the court is asking for. And so in order to answer that, we need to look at, first of all, does the government have the right to regulate us under the concept of public health, public safety, or public welfare in the first place? If the answer is no, then do the other three, or do the rest of those questions really have any merit? No. I'm going to answer them, though, in case they want to keep digging down that line of thought. But let's look at public safety, okay? The term safety, not even public safety, the term safety only appears once in our whole United States Constitution. Once. That instance is found in Article 1, Section 9, where it states the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. So literally what it's saying here is that this provision, it provides no governmental authority to act on public safety, but for the rare need to suspend the writ of habeas corpus. That has nothing to do with my child running up and down. Emma, you need to get your work done, please. That has absolutely nothing to do with our governor saying movie theaters can't be open. That Article 1, Section 9 of our state constitution, just think about, does it even make sense? It doesn't take an attorney. It doesn't take a Supreme Court justice to figure this out. This Constitution, both of these constitutions were written by the people, for the people, you. They're not written for some overpriced attorneys to go figuring out some other, in some high-priced room in some high-priced office somewhere. No. It's for we the people to read and understand. So does it make sense if we're talking about the only time safety is mentioned in the U.S. Constitution is talking about suspending the writ of habeas corpus, that has anything to do, and mind you, during a time of rebellion or invasion, that somehow has anything to do with the governor shutting down movie theaters or requiring people to wear masks? I don't think so. So if it doesn't make sense to you, it's not because you're stupid, it's because you're actually listening and you're paying attention and you're reading the Constitution. So thankfully, we're able to talk about these things. So our Michigan Constitution mentions the word safety 6 times. Okay, that's a little bit more. Only 3 of those are in the context of public safety. We have Article 1, Section 27 that involves patient safety. We have Article 4, Section 50, that involves safety measures for atomic energy, which we actually already talked about, and Article 9, Section 40, that involves safety education programs for off-road vehicles and snowmobiles. It's just offering educational programs. It's actually talking, I believe that provision is talking about funding for offering educational programs. So not requiring anything of people. So that leaves only 3 provisions then, right? So these 3 uses of that term only provide our government the authority to suspend the writ of habeas corpus when rebellion or invasion requires it. Yes, it's the same thing I just said in the United States Constitution, Article 1, Section 9. We have the same provision, I believe, in Article 1, Section 12. Yes, Article 1, Section 12 of our state constitution, almost word for word, is the same thing as Article 1, Section 9 of our U.S. Constitution. The second way safety is mentioned in the United States Constitution is to provide for the protection of the air, water, and other natural resources of the state from pollution, impairment, or destruction. We already talked about that one. That's Article 4, Section 52. And the third one is to own real property for the benefit of the public health and safety. That is Article 7, Section 23. State and municipal governments are allowed to own public property for the benefit of public health and safety. So I want to say it talks about public parks and hospitals and things like that, that they're allowed to own public property, own real estate for the benefit of the public. Again, that doesn't say that people can be regulated in any way under the guise of being kept safe by, the government's going to keep us safe. That's it. Those are the only types. Hey, Ems, can you take care of this, please? Thank you. Those are the only times that the U.S. Yes, please. The only times that the U.S. or Michigan constitutions use the word safety at all. So what did I say? That was one time. Yep, one time in the U.S. Constitution. And in the context of public safety, 3 times in the state constitution, but none of those are regulating the people in terms of going to church, going to the movies, which items they can buy, whether they have to wear masks in public, whether they have to be socially distant, whether they can have a wedding or a funeral or any of those other kinds of family activities the way they would like to. So what about the term health, right? Because this is, thanks, Emma. I'm sorry, I have the cutest 6-year-old in the entire world. I'm not biased or anything. It's just true. Hi. Okay, you need to finish your work. Friends are starting to come home from school.
Well, friends are already home.
Oh, not all of them. So get your work finished. Okay, so the term health appears nowhere in our U.S. Constitution. Literally nowhere in our U.S. Constitution. Did you know that? So what authority really would any government have to protect the public health if the U.S. Constitution, that is the basis, the foundation for every other governmental entity that we have here in the United States, right? If a state constitution cannot go against the U.S. Constitution. And I want to say it's the 10th Amendment that says all other rights and powers of the, not specifically given to the government there are reserved to the states and to the people. I guess maybe in that sense that the states could have chosen to regulate health. But let's look at the term health then. So health appears nowhere in the U.S. Constitution. So the term health appears only 4 total times in our state constitution, but only 3 of those relate to public health. So if we look at Article 9, Section 36, it talks about tobacco-related tax proceeds are meant to benefit health care. And that doesn't relate to regulating people with masks or public health requirements. That's again talking about a tax on cigarettes that is then used for educational purposes or basically to benefit the health of the people. So the two of these other, so there's three then remaining, right? 3 times the word health is used in our state constitution that relates to public health. 2 of them give our government the authority to provide for, you guessed it, the protection of the air, water, and other natural resources of the state from pollution, impairment, and destruction. And that is Article 4, Section 52. And to own real property for the benefit of the public health and safety, which is Article 7, Section 23. I don't think either one of those allow them to require us to wear masks. The remaining reference to the public health is found in Article 1, Section 50, Article 4, Section 51, which is that one the governor keeps trying to use as a tool to beat us over the head with. And that requires that regulation, quote, for the protection and promotion of the public health, end quote, to be suitable, which I would argue, among other things, means respecting of our constitutionally protected liberties, including those that remain unenumerated. What does that mean? In Article 1, Section 23, we have a very clear statement of our state constitution that says we've listed all these other rights that we have, but that doesn't mean this is all of them. We, the people, retain all the other rights given to us by God, even if we don't list them out. Also, I believe it is the 9th Amendment to the U.S. Constitution says the same thing, that there are unenumerated rights that the people retain because they're given to us by God, and we don't have to list every single right that we have. The point of the government is to specifically protect our rights, and so by specifically spelling out the ways that certain rights are listed, that's the forewarning to the government. These are the ones you're supposed to help protect against. Protect, right? You're supposed to help protect these rights, period. And the other ones that aren't in there mean that the government still can't trample on those rights that are not listed, but they maybe don't have that specific duty to protect those rights because we didn't give them forewarning about those rights. So anyway, so the regulation for the protection and promotion of public health has to be suitable and done exclusively through the legislature, not the governor. It doesn't say the legislature can then have the governor do it, because that's Article 3, Section 2 of our state constitution that says, no, you can't delegate your powers. You cannot exercise powers of one branch while you're exercising powers of another branch. So although it is thought by some people that our state government is responsible for public health, public safety, and the general welfare or public welfare, those general powers have no basis in our state or federal constitutions at all. And let's think of it this way. Our entire state constitution was established simply because, quote, we the people of the state of Michigan are grateful to Almighty God for the blessings of freedom and earnestly desire to secure those blessings of freedom undiminished to ourselves and our posterity. If we wanted to create a form and structure of government and a set of definitions for governmental power to ensure our public health, our public safety, and the general welfare, we would have stated that. But we didn't. We said we're creating our state constitution to protect our rights that are given to us by God. That's why our state constitution exists. That's why our state and local governments exist, to protect the rights given to us by God, because we want to make sure those blessings are undiminished to ourselves and our posterity. So the term public safety, I mean, that should really say it all, right? But then I didn't really answer the rest of their questions, so I continued on. So they're asking if the term public safety as used in the Emergency Powers of Governor Act is a term of ordinary meaning, or if it has developed a specialized, what was exactly the question here? Hold on. if it has developed a specialized legal meaning as an object of the state's police power, and whether public safety encompasses public health events such as epidemics. So basically, I used a bunch of case law, if you want to call it that, that basically says it's not the government's job, it's not the court's job to add different, changes to things over time or to overcomplicate something. If the text of the Constitution is clear, you go with what the text of the Constitution is. In fact, if the plain language, if the ordinary meaning of a word is what is intended to be used, because it is the people that are supposedly enacting it through an act of the legislature or some other means, then you have to go with what the wording of the people in general would have thought the word to mean. You can't assign some other special legalistic meaning to it. So I would say, especially the fact that the terms public health, public safety, and public welfare are grounded in our constitutions, that those terms and their meaning is fixed at the time that those constitutions were put into place. They're not transient, they're not changeable, they're not morphing. So basically what the court has said is that to read the law consistently with its language rather than its judicial gloss, some fancy way of the court viewing it and trying to change it and make it prettier, right? But to read the law consistently with the language itself that's in there is not to be harsh or, ridiculous, right? But that is the one way to give the people at least a fighting chance to comprehend the rules by which they are governed. Is that some really old case that I'm referring to? Is it something that maybe was so long ago that the courts would never think it applies today? Well, not exactly, because that is actually language that I quoted right out of the 2018 Michigan Supreme Court case, that citizens case I mentioned. So the very justices that are on our court today understood that concept back then and should understand it today. So again, the court says that when they are employing use of the tools of judicial construction or judicial interpretation, the court must ensure, quote, this is their language, that language must receive such a construction as is most consistent with plain, common sense, unaffected by any passing excitement or prejudice. And that's been a driving force behind reading into statutory language since 1865 in the state of Michigan. You can have a break until 4 o'clock. Where's your watch? I don't know. So Twitchell v. Blodgett is the case from 1865 that says that. In fact, there's a lot of really good stuff in that case. And that's our Michigan Supreme Court. And why is any of this important, you might ask? Well, because they have also said, and this was in the same 1865 case, that the rules of law are supposed to be permanent. It's not a changing, morphing rule of law. It's supposed to be permanent. Why? Again, because the people need to understand the rules. If we're a government of the people, by the people, and for the people, then that's kind of a basic concept, right? So anyway, I kind of go into explaining, looking at the language of the EPGA itself, right? The 1945 law. It talks about public safety in the context of great public crisis, disaster, which is defined as calamity, rioting, which is defined as turbulent, disorderly terrorizing of the public, catastrophe, or similar public emergency. That demonstrates the use of the meaning, the use of the word within the ordinary meaning of public safety, not some specialized legal meaning. Also, public safety, like I said, does not encompass the word or the meaning or the term of public health. Public safety, public health, the general welfare of the people, those are three distinct concepts that a lot of our government has been lazy in trying to roll all together and confuse the public about. But it has officially been recognized as three distinct concepts. So, again, if you look at MCL 10.31, that is the 1945 law, it says that in times of great public crisis, disaster, rioting, catastrophe, or similar public emergency within the state, or reasonable apprehension of immediate, you can't find it? Okay, you stay in our yard. Don't go anywhere. You got shoes on. Get shoes on your feet. That immediate danger of public emergency of that kind when public safety is imperiled. That's the context they're talking about public safety. So when we use terms, these like terms, right? And then we reinforce that by the use of limiting words like similar and that kind, we're speaking volumes about the types of perils the legislature in 1945 was trying to address. It's not some laundry list that's just infinite. Hey, whatever the governor thinks is an emergency, let's just go for it. It's not at all what it says. And it's important that we actually look at the words that were voted on, not the meanings that people have added to them afterwards. So, for example, tornadoes, terroristic behaviors, widespread electrical fires, and other urgent, dangerous, and external threats to our safety are the types of perils the legislature wanted to empower the governor to protect us against. So surely by that time in history, 1945, we knew of plagues, illnesses, diseases, and all that stuff, right? But none of those internal threats were even alluded to here, let alone actually included by the wording of the statute. That's in the 1945 law. That's one of the reasons why I've been saying to people, one of the reasons why I've been saying to people, the 1945 law has nothing to do with any of this. Repealing it isn't necessarily the problem because she's not following the law. Statutes that relate to the same subject matter, well, you guys probably should know this legal term by now, this Latin term. Statutes that relate to the same subject matter or share a common purpose are in pari materia and must be read together as one law. That's to effectuate the legislative purpose as found in harmonious statutes. Basically, they're saying we're not going to assume the legislature goes in there and just writes, random laws, right? Passes random laws every single legislative session, that they do so knowing the laws of the legislative sessions before them. And the whole thing is one big legislative scheme that must be read together, if at all possible. And if it can't be possible to do that, you always have to look to the more recent statute to explain things, especially if it's one that's more specific. Because oftentimes, like in here, the 1976 law is more recent and it's more specific. That 1945 law is older and it's more general. So yeah, the legislature is saying, obviously, you should look to the one that is defining or fine-tuning what we put into place 3 decades prior, assuming it's all constitutional. So I talk about that at length. And then let's think about this, though. If you look at all of our statutes being part of this bigger picture, right? Well, public health is entirely separate than public safety. For starters, they are literally 2 entirely different departments within the executive branch. So MCL 16.525 created the Department of Public Health, which, quote, is pursuant to Section 51 of Article 4 of the State Constitution of 1963, that they shall continually and diligently endeavor to prevent disease, prolong life, and promote, not regulate, promote the public health. While if you look at MCL 29.362BB, that defines the Public Safety Department as a department of a political subdivision providing both law enforcement and fire services, either separately or utilizing a combined response force with personnel trained and certified as both firefighters and law enforcement officers under the direction and administration of a single director. Also, we can look at MCL 70.18 subdivision 3 that makes public safety departments, quote, responsible for the enforcement of law and order, the protection of life and property against fire, and the performance of other public services of an emergency nature. Or if we look at Act 59 of 1935, it was enacted to, quote, provide for the public safety, to create the Michigan State Police, to provide for the organization thereof, to transfer thereto the offices and duties and powers of the state fire marshal, state oil inspector, and the Department of the Michigan State Police as heretofore organized, and the Department of Public Safety. So basically in 1935, they said the Michigan State Police is now going to have duties from the state fire marshal, the state oil inspector, the state police as they already existed, and the Department of Public Safety. All of those are now going to be under the name of the Michigan State Police. None of those have anything to do with public health, because the Public Health Department, again, was created under an entirely different statute and serves an entirely different purpose and is put into effect by entirely different people. So then the court was asking, does the EPGA apply to situations of public health generally, or even to the specific context of COVID-19 or epidemics? So I said no. They're totally different. I said if we look at the ordinary meanings of the terms as used in the EPGA, with the term public health appearing nowhere in the EPGA, doesn't say public health anywhere in there, we must use, or public welfare, we must use the basic canons of statutory construction to determine, essentially, should the court read into that law that public health is part of it? No. You have to have a really good reason for reading into the law that some other words should be part of it. Because basically that would be the court saying the legislature is a bunch of idiots and they meant to include this other term, but they didn't. So if we look at the bigger scheme, it's abundantly clear that public health was never intended on being read into that law. In fact, if we look at, here's an interesting one. I don't think I've talked about this in any videos yet. So Chapter 10 of our laws reveals how the legislature intended these emergency statutes to interplay. So I've talked about Chapter 10. That's where 10.31 is. That's where the EPGA is. But if we look at 10. Which one is this? 10.87. That is the Act 191 of 1982, coming after both the EMA and the EPGA. It's called the Declaration of State of Energy Emergency, and in there, the legislature made it a point to state that, quote, this act shall not limit, modify, or abridge the authority of the governor to proclaim a state of disaster pursuant to MCL 30.401 to 30.421. Basically, they're saying the EMA, right? So, because the EMA is all those statutes. So, the act shall not limit, modify, or abridge the authority of the governor to proclaim a state of disaster under the EMA, or to exercise, or to exercise any other powers vested in the governor of the state by the state constitution or other laws. It says the power to declare a state of emergency or state of disaster. So you have this specialized state of emergency that was created in 1982 for the governor. And in there it says, hey, she still has the authority under 1976 law to create those states of emergency or states of disaster. And any other kinds of power she has. That means they're not relying on the 1945 law or looking at that as some sort of independent source of authority. But anyway, that's a different thing. So, other statutes, I list a whole bunch. You can look at them if you'd like to. I hope you do. Quite frankly, I hope you do, because it gives you a ton of information. That, for example, the Public Health Advisory Council was created to advise and consult with the director of the Department of Health on public health programs and policies. So also local health departments are to continually and diligently endeavor to prevent disease, blah, 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 promote life, prolong life, and promote the public health, including the prevention and control of diseases. Isn't that what the governor's trying to do in these COVID-19 orders? Prevent and control the spread of diseases and prolong life. Oh, yeah, and especially this part, the prevention and control of health problems of particularly vulnerable groups. Isn't that the class of people that are specifically hurt by COVID-19 the most? People that are dying of COVID-19 are those who have other comorbidities. They're already vulnerable groups. Well, the job of protecting the health of those individuals has nothing to do with the governor. It's already written in a couple different statutes about who that belongs to, if it really belongs to anybody. But that constitutional discussion, that's going to be too much for some people to get at in the legal profession. It'll be too much for some of those people. So local health departments are to adopt regulations to properly safeguard the public health and prevent the spread of diseases and sources of contamination. I give you all the different statute numbers to these. It's a whole bunch of them. I have dozens. I would guess I have dozens. I don't know. I printed thousands of pieces of paper about them. Nope. Let's see. The Department of Public Health has the general supervision of the interests of the health and life of the people of the state, and to make investigations and inquiries into the causes of morbidity and mortality and the causes and prevention and control of sources of illness. That's what the governor's trying to do with these executive orders. I have all the data. I have all the science. I have all the experts behind me, and I'm going to tell you what's good for you, and you have to listen to me because it saves lives. So mask up, Michigan. Really? It's not even your job. It's the job of these other people according to state law, supposedly, assuming it's constitutional. So we have, I just put a ton of information in there from other statutes. Epidemics, listen to this part though. Epidemics are specifically intended to be handled by individuals other than our governor. So we have, for example, MCL 333.2221 subdivision 2 and 333.2433 that says that the local health departments, both the local health departments and the Department of Public Health, are supposed to make investigations and inquiries into the causes of disease and especially of epidemics. I didn't add those words. Especially of epidemics is in the statute of our public health code. The director of the Department of Public Health is given authority to control an epidemic. We have, I'm just trying to glance over this stuff. In fact, the Department of Public Health is supposed to establish and maintain a pandemic influenza plan. Didn't know that was a thing. I didn't. Now I do. So it doesn't matter how you slice it, whether you look at the definition of public health in general, whether you look at how public health might interplay with public safety, and does public health, is that part of public safety? It doesn't matter if you look at the EPGA and how it mentions public safety, and you try to figure out if a pandemic or epidemic is supposed to be inserted into that definition or list of events. It doesn't matter if you look at, well, this epidemic thing, let's just look at epidemics like COVID-19 in general, and how does that affect anything? All of those things, all those ways of looking at it get us to the same conclusion, whether you're looking at state statutes or whether you're looking at the US Constitution or the Michigan Constitution. The governor does not have the authority to do what she's doing, and public health and public safety and public welfare are separate things. And the Constitution does not allow the governor to do what she's trying to do. It certainly doesn't allow her to do it under the 1945 Act. So, at any rate, I also, in the end, reminded our justices that we all, every single one of us professionals who are involved as a member of the executive branch or as a court officer or as a member of the judicial branch, we took an oath of office. And there's an oath under Article 6 of our U.S. Constitution and Article 11, Section 1 of our state constitution to enforce, to support the U.S. and Michigan constitutions, whether we like it or not, period. So in the end, whether you feel overwhelmed by all the terms and definitions and different things I threw at you, hopefully you got the basics that no matter how you slice it, it's not constitutional. And whether the justices like it or not, we have to follow that Constitution. We have to follow both of those constitutions. And it doesn't matter if the data says we should do this, or if the numbers say this, or if the doctors are disputing whether wearing masks is effective. It doesn't matter. The law and the Constitution are clear on the points presented before the court. So hopefully that gave you an understanding of what was talked about, what my position is on it, what I strongly believe is the people's position on it based on what the Constitution says. And I've already at the very beginning talked about the timing and all of those aspects and other things that went into it. As I mentioned earlier, I can't scroll back for some reason, so I will be helping on a list of people to vote for. I haven't had a chance yet. I wouldn't trust the Right to Life list. I mean, just to be honest, and I was endorsed by Right to Life when I ran for state rep years back. So it's not a, like, they're against me kind of thing. But I don't trust their list because I know of people who have been on their list that are not in favor of freedom or of life, quite frankly. Who said catastrophe included COVID? There's nowhere in there, if you look up the word catastrophe, that it has anything to do with an epidemic. Not even close, especially when you look at that list in the context of how those particular words were chosen and used together. They're talking about external threats. Something that's inside of your body is nothing at all related to that list of things. It'd be very interesting for me to know how they said that. I'm almost done, Ems. I'm just looking for last questions here. Could the Supreme Court come back and say that that Michigan Department of Health and Human Services is strictly not for regulating public health? I mean, they certainly could, but not in this particular case, I don't think that would be. Well, the director of Department of Health and Human Services was definitely involved. I don't know. I guess that could be. That is something that could happen here. I'm hopeful that it would happen, but I have not given up any sovereignty. I don't know about you, but the American people need to wake up and stand up and fight for what's ours, which is the rights that were given to us by God. I have not given up any of my sovereignty. God gave me those rights, and I, as a part of we the people, did not hand that over to the government. No way. If they said it is not for regulating the public, then we can finally stop them from the draconian power they have been placing on the people once and for all. I believe they could. I believe they could do that. I believe that's what it would come to. But if not, no matter what a particular court says at a particular time, please keep in mind the Restore Freedom Initiative constitutional amendment petition is meant to surpass any passing indications of what a certain court thinks is the right way to handle it, or what a certain governor thinks is the right thing to do. Because, of course, different governors are going to do different things. Different courts are going to say different things. In the end, we need to have a rock-solid constitution, and that's why that constitutional amendment is so important, because it takes away all the extra fluff and garbage and loopholes that were added over the course of the last however many years. I can't do the math, since 1963. Exactly. So the disease of COVID-19 itself, I mean, it's not worse than cancer. It doesn't kill nearly as many as people as the flu, but definitely it is bad. And it has opened our eyes to just how fast they want to take away our rights. Absolutely. It also taught us what parts we need to clean up. Exactly. I would agree with you, Nathan. Health and Human Services can regulate. I don't know what I said that changed the concept of what you were going with, Maya. Why aren't they looking into the cause of autism? Because government can't be trusted at all, which is why we need to be more careful about the reading of the Constitution and the powers we actually gave them. Absolutely. No, she doesn't know the facts or the data or the science. No, our governor does not. Anyway, that's for another day, because it's irrelevant. I mean, honestly, it's irrelevant. Let's say she had all the data on her side. Let's say she had so much data that really proved what she was doing was necessary, that she was disclosing it and truthful to the whole public about it and not hiding this data. It still wouldn't change what the Constitution allows. That would just provide the American people reason, or the people of Michigan, the reason to follow recommendations coming from her, but she still wouldn't have the right to regulate us at all. Eek. So in a nutshell, I guess I don't know what you mean by that. I've given a lot of nutshells. I've tried to reword it a variety of ways. So if there's something else you're still looking for, Kristen, let me know. We the people, Donna, we the people are in charge. Who the heck is in charge here? Why is nobody stopping her? People in office need to step up. Yes, they do. But it's really we the people that need to step up and fight for this. Don't leave it to someone like me. I'm nobody without you guys. I'm standing here to be the voice for the people, to get you guys educated and therefore engaged and fighting for what we have to fight for, which is our freedom, our rights that are guaranteed to us by God. Don't look at any government official to fix this for us. They're not going to, unless you daily put on the pressure and you tell them who their boss is in every possible way. You email them, call them, go in public. You speak by voting. You speak by going to local city council meetings or, sessions of the legislature. You write and email all of them. Whatever it takes, you let your voice be heard. You hold freedom rallies. You hold medical freedom rallies. You do whatever you need to do to get that point across about who is in charge. It's not the government, not unless we let them be in charge. It's we the people. We the people. Absolutely. That's funny. I just noticed that Lori decided to say that back to Donna that we the people must hold our representatives accountable. That was a much more succinct way of responding, I guess. Oh, Maya, of course we should sue Health and Human Services, but for about 1,500 reasons, not just the one. But let's be honest, and of course I'm with you on that, but we have, the problem is so much bigger than that. Let's put them in their place. Let's box them into the place in which they belong in the first place, and then worry about sorting out all of the aftermath later. So the ways that they went wrong, right? So let me put it this way. Before you start rebuilding the house, you put the fire out. We need to put the fire out, and then we can rebuild the house, right? So we can fix all the damage that was caused, but we need to stop the destruction from occurring in the first place. That's what we need to do now. That's absolutely what we need to do now. I know, Sue. I wish I could have explained my brief verbally as well. Absolutely. And that's why I said to people at the beginning that I really don't think the court's going to want oral argument on this, but I specifically asked for it in the event that they do. So hopefully we do get that, but okay, shoot, there was another question. So Donna was asking specifically about who to contact. If you go to, there's really a lot of websites. I mean, quite frankly, I think you could just Google who are your state representatives or who are all of your government officials. Sheriff, prosecuting attorney, judges are by county. So you can just go to your county and your county website would list all the different departments is probably what it's going to be under or something of that nature. So all of their contact information in theory is there. And then you can go to the Secretary of State and plug in your information and it'll tell you who your state representative is and your Congress district and all those things. So you should be able to get information. I believe last I looked, they had hyperlinks. So you could click on who it was and it would take you to that government office. You could contact them directly that way. Yes, Kevin Skinner does have a group. He told me about it. I've been trying to write these briefs and stuff this week, so I don't know anything about what they're doing other than they're working on it. So hopefully when they have that done, I can take a look at that and I'll be able to figure out if I concur, with their findings on who would be good candidates or not. Can we be made to wear a mask? No. I have a lot of other law and constitutional provisions that can back that up, but in the end, the answer is no. Found it hard to find info about judges for voting purposes. Yep, we're gonna work on that. Oh, let's see. One of the other attorneys said if COVID is not a catastrophe, then what is? It is said during the hearing and should be on the Supreme Court. Well, and you know what? I was there for the hearing, but that might have been one of the 2 times I had to turn my video feed off so I can run to the restroom because it was a long hearing and I was drinking a lot of water. If it's not a catastrophe, then what is? Well, if she looks up the definition of what a catastrophe is, that's basically, if you want to think about it this way, there's that movie, Lemony Snicket's series of unfortunate events or something like that. So you have something could be a disaster. It could be something where this you know, this thing went wrong, this external thing went wrong, there was an electrical fire, there was this, there was that, right? So let's say there was a tornado that was so huge and so ferocious that ended up coming through and knocking down a bunch of buildings, but then it also started fires, right? Electrical fires, and it caused flooding by whatever. It took out some dams or something of that nature. And so there were areas that were totally flooded, and then you had areas that had fire, and then the electrical fires ended up being close to very wooded areas. And so then we had forest fires that were engulfing huge acreages. And so all of a sudden we're dealing with fires, and we're dealing with flooding, and we're dealing with the buildings being destroyed, and we're dealing with all of that. That would be a catastrophe, right? That would be a catastrophe. COVID-19 is not a catastrophe. So we could think of a lot of other reasons or ways to describe catastrophe, and we don't have to try to reinvent the term to fit that. So it was a nice try on their part, and maybe she really believes it. I think you're talking about the AG's attorney, I think. How are state laws even enacted when they're in conflict with the state constitution or US Constitution? Exactly. They shouldn't be, but guess what? That's when we, the people, have the right to do a, what is it called? Referendum. I want to say it's in Article 2, part of our state constitution. Take a look at the state constitution. There's a part in there where it can be challenged that there's a law that's unconstitutional. Now, the problem is when they're passing that many things, right? If they have Public Act 500 of the year 2020, that means they have passed 500 statutes. So 500 bills, right? Or packages of bills. So it's a lot to keep up with. They shouldn't be passing that many. We need to keep a better vigilance about that. Robert Bowes, you always stump me. And in fact, I still have to get back to your uncle on his property tax question. I have not forgotten. And I did see your most recent order come through as well. And I'm assuming you don't want me to ship those constitutions to you because you're going to pay me a visit sometime soon. I love when especially west side of the state captains are able to make it for a visit every now and then. I mean, hey, if you're a captain or circulator and you want to drive all the way across the state to come and visit, by all means, please do. But I know that's a little bit harder for people that are, like in Detroit or Houghton Hancock than it is for people that are only, Van Buren, I don't know, maybe an hour away from me. Something was asked about the Commerce Clause of the United States Constitution can overrule the Supremacy Clause. I'm not sure what was asked, what the question is, if it was something that was in a prior question here, but I'm not sure how to answer that. One county stood up and discontinued the COVID mandates. Which county is that, Katerina? I would love to know. I definitely need to know which county said in general, overall, they are just done enforcing any of it. Alcona County? Really? I'm going to write that down. Alcona County, that's awesome. I will be checking into that. If you have any links for me on that or something, that would be great. Oh, of course she should be held accountable for the deaths and all the financial losses, but not as a governor, as a person who stepped outside of the authority of the office of governor, because our state should not have to pay to defend that lawsuit. Our state should not have to pay for the deaths or the costs that result from that. It should be her. She did it. The people of Michigan didn't do it. The people of Michigan shouldn't have to pay. She should. No, a privately owned business does not have the right to not allow us in their building if we don't wear a mask. Nope. Do they have a right to deny a person access into their building because they want to design their hallways all this narrow so people with wheelchairs can't get in? No. So let's just look at the part of disability alone, okay? Let's just look at that for simplicity's sake. If somebody cannot wear a mask because of a medical disability, which is allowed in the governor's orders, it's recognized that people are not going to wear masks at times because they have medical disabilities or medical reasons why they can't wear a mask. You really think that a private business that's not allowed to discriminate on disabilities for any other reason would be allowed to discriminate against you for not wearing a mask for the COVID-19 reason? No, they don't have a right to do that. Not even close. And for those people that have said, well, a private business can just stop, they could stop you from coming in and they can just deny you the right to do whatever. No, they can't. If they don't like the color of shirt you're wearing, okay, but then what? What if they don't like the color of my skin? Are they allowed to deny me service because of that? What if they don't like the color of my hair? What if they make an assumption about me based on the vehicle I drive up in? What if they don't like whether I have children or whether or not what if I have my daughter with me, but my wedding ring is getting cleaned and so they think I'm a single mom again, which I have been, but I'm not now. So let's say they're deciding to discriminate against me simply because they think I'm a single mom. Do they have a right to do that? We have equal protection. And here's the thing, it's equal protection of our laws. But when a private entity is enforcing a government mandate or executive order or a state law, if the government is being, if a private business is enforcing a government rule upon the people, then in that aspect, they're stepping into the shoes of the government. And so all the rules of the government apply to them, meaning that if the government cannot violate our right to equal protection, neither can the private business. If the private business does not want to have all of those restrictions upon them, then they need to not act like they're going to enforce the government's orders. So if she wants to try to enforce people wearing masks, but the business says, hey, I have nothing to do with that. That's not my thing. I'm not a government agent. People are going to wear a mask or not wear a mask. Then there you go. But when they're enforcing these things based on what government agencies are forcing them to do or requiring them or requesting of them or what it says in an executive order, they are becoming an arm of the state. My thoughts on the attorney who was saying a forced COVID vaccine wouldn't be unconstitutional. He's an idiot. I'm just going to say it that. Let's pretend there's no other source of law or constitution or anything that I could pull from any other thing, right? Let's pretend that's the case. I could just rely on what I shared with you guys today in here. What did I share? When I talked about public health or even general welfare or even public safety, how do any of those things give the government the right to mandate a vaccine of any kind? Just because it's currently being done in a variety of aspects doesn't mean they have the right to do it. It just means we haven't stopped them from being unconstitutional yet. Oh, it was the male attorney.
Can I go play?
Where?
At the Deepsters?
Outside? In the front yard?
Yes. Right in the front yard.
Yes, if you stay in their front yard and put your shoes and socks back on your feet. So, oh, it was the male attorney. Well, he said a lot of things. He said a lot of things. In fact, he was the one that, when I think it was Justice Viviano was questioning him about my statement that it had been 183 days that we'd been under this state of emergency. He said, well, I don't know. I haven't been keeping track. I don't know how many days. Oh, well, there you go. Less than an hour away. That's good. So I don't know if any of you saw, because someone said the biggest problem is trying to get an attorney to fight the illegal city mask mandates. If somebody is given a ticket or citation or anything regarding these COVID-19 illegal, unconstitutional orders or mandates, I did post the business card of an attorney. I think his name is Jim. He's one that's involved with the recall effort. I'm not personally recommending him because I don't know his work quality. I'm not recommending him. I'm giving him to you as an option of someone who told me face to face yesterday that he will take on those kinds of cases to defend you from getting those kinds of citations or tickets. Okay, Jeffrey, I see that you tried to clarify, but I don't understand the clarification. Commerce Clause versus Executive Orders to Supremacy Clause. There's no right to have those executive orders at all under the Supremacy Clause, the Commerce Clause. So I just feel like I'm missing what the question is. Oh. Okay. Of course, Robert, I'm telling you, any of you who have asked me questions, if I have not gotten back to you, it's either because I don't have an answer yet, or because I have simply run out of time and I'm trying to put out the biggest fires first and coming back to the others. I am trying very hard to make sure I answer all of the questions. Yeah, Karen, they don't have a right to do that. I don't care if they're private property. They don't have the right to discriminate against people for all those other reasons. That's part of when they're acting on the behest of the government, especially. They don't have the right to treat people differently. That's not acceptable. Sam's Club can't discriminate either. I have a membership and I've been in there. And I don't wear a mask. I have a medical exemption, and it's not their business to know anything about that. And because of my hearing disabilities, my family who is with me also has exemption to not wear one. So if they're being jerks to you about it, that's not their right to do it. They don't have a right to do it. They're just doing it. And I'm sorry that they're doing that to you because they don't have the right to do that. And Gordon Food Service, shame on them. They don't have a right to do that to you either. They're worried about being fined because you have a medical exemption or because you have any kind of other exemption. They don't have a right to dig into that. Even the governor's unconstitutional executive orders allow for those exemptions. I don't know why these businesses are just being idiots. Mm. Well, I'll tell you what, Joanne, I have a child. In fact, my youngest child, who is 6, was with my oldest child, who is 19 and a GVSU student. She was with her for a couple of nights to spend some time there, and our oldest child is going into education. I gave her some of the books that we have, homeschooling, that are more direct teaching types of things. Anyway, point being that Ottawa County Health Department and JVSU made their big announcement that students have to stay home and can't even go to their parents' homes, while my youngest was at the oldest's apartment. And they are the only people in that county under this order. No, it's not legal. It's not legal and it's not constitutional. And no way are any of those students going to be allowed to be facing misdemeanor charges because they leave their apartment or they leave the dorm. Absolutely not. And yeah, over my dead body, is that going to happen? No. Well, but at least I'm not okay with the child vaccine statutes that we have, but at least with the child vaccines that we have, they have exemptions. And it's not just medical exemptions. There's other philosophical or religious exemptions. There's exemptions, and they can't question you on it. So at least there is that. This, they're just, yeah. Oh, the case, yeah, you were, okay. Brian, yes, I did talk about that Pennsylvania case when I first went on. So when the video closes out and you can go back and watch the beginning, I did talk about that a little bit. I haven't read all 66 pages of the order, but I do describe that, what the case does, what it doesn't do, and gives you some context for that. You do not have to have a physical letter from your doctor to prove a medical exemption. Executive Order 153 is the mask mandate one, and it specifically says that the store can simply rely on the verbal representations of the customer. So if you say to them, I have an exemption, they don't have the right to question you about what disability you have or what your medical condition is at all. Even the governor's unconstitutional executive order does not allow them, it does not give them permission to start digging into your medical conditions or your history. No. No, so no, you don't have to have an exemption, Lori. You do not have to have an exemption letter. I do carry one for one of my exemptions, quite specifically for one type of service that I needed. And in the end, the fight against them was more than what my, in my own personal life, I could take on for that one particular thing. I don't show my letter, my exemption letter. I don't even tell people that I have a letter to any other place. If I walk in to get a pizza and they try to stop me, I just tell them I have an exemption. I went to a gun store yesterday and they tried to tell me I needed to wear a mask, and I said, no, I have an exemption. And I don't tell them, oh, I have a letter, it says this, this, and this. No, because we're not legally required to do that. It's honestly a matter of when people are when they're acting unconstitutionally or illegally, what is the level of fight you want to bring to it? So, I mean, my husband went off and tried to tell them, I have an exemption. Yeah, it's the Constitution. And I could tell by his demeanor, it was going to go all downhill. He wasn't wrong in what he said. But in that moment, the gun store closed in 10 minutes, and I was going there to look at something that was being held for me, and I didn't have the time to get into a big fight about those things. I needed him to come into the store with me and look at the gun that was being held. So it's just, what are you willing to do in those particular circumstances? That's the only reason why you would need to have a letter. It's not a legal requirement at all. Well, the 1905 Supreme Court did not give me my rights. God gave them to me. And the 1905 court did not specifically protect my rights in the Constitution. We, the people, did that and cemented those constitutionally protected rights. And the 1905 case, as somebody pointed out, was really about whether the guy wanted to pay the fine for not getting the vaccination, which again, I think the ruling is entirely terrible anyway, but it is a different, a bit of a different issue. Jillian, I don't know if the legislature ever fixed the clause about microchipping in the courts. I don't. I would like to know where they stand with that, because as far as I know, they didn't fix the damages clause for sure. That is still an issue, which was, I believe, Section 4 of that House Bill 5672. Executive Order 153. Executive Order 153. I bring it around sometimes. I have it on my phone. My husband and I have definitely pulled it up. Yeah, Ruth, they don't have the right to do that to you. They don't. But again, governments and private businesses and agencies and everybody in between, that people do things they don't have the right to do all the time. It doesn't mean just because somebody is doing it and getting away with it means that they have the right to do that. It just means they're getting away with it so far, because it's going to take people like us fighting for our rights. No, medical providers, Luann, medical providers are not allowed to refuse your service if you don't wear a mask. It's despicable, because they're the ones being the biggest idiots about it all. I'm disgusted at the medical providers that are saying, I won't treat you unless you wear a mask. It doesn't follow the medicine. It doesn't follow the science. And these are unconstitutional executive orders. And they took an oath to do no harm, I'm pretty sure. But then they're going to do harm to people if they can't wear a mask and then refuse them treatment. Oh, Lisa, if they rule against us, we need to keep fighting all the way. Everything we're doing, we need to keep doing it. Oh, Maya, don't tell me that. I can't take on the post office right now, too. There's way too many. There's way too many to fight this, but I'm going to do my best. I'm going to do my best to work on all of this. Of course, Jack O'Malley voted for it, because Jack O'Malley is not about freedom. He's not about liberty. If you listen to what he's saying, he said it's okay to implant somebody who's been charged with a crime. It's okay for them to have a forced implantation of a medical device, of a microchip, so that we could track them. Because they're no longer a human being. They're just an animal that we could force to be microchipped. Okay, I think I got to all of them. And I have somebody here. So I have to go, everyone, but I wanted to thank you all for tuning in. It's been informative for me, informative for you. Come on in. I hope you all have an absolutely wonderful day, but I need to talk to one of my, I believe she's my Van Buren County captain. So, Robert, no, I'm not talking about you. I'm talking about the other Van Buren County captain. But I hope you all have an absolutely wonderful day. Enjoy the weekend. Fight for freedom. Don't take a day off from getting those signatures, and don't take a day off from paying attention and being aware. Okay. We need to fight for our freedom every day right now. Thank you so much, guys. Have an absolutely wonderful day.